How to memorize amendments for FCLE. Question 1. Which constitutional provision requires that all bills designed to raise public revenue must originate in a specific House of Congress? Option A. The origination clause requires them to start in the Senate. Option B. The origination clause requires them to start in the House of Representatives. Option C. The presentment clause requires them to start in the executive office. Option D. The supremacy clause requires them to start in state legislatures. The correct answer is option B. The origination clause requires them to start in the House of Representatives. The origination clause requires revenue bills to begin in the House of Representatives. It does not require revenue bills to start in the Senate, executive office, or state legislatures. The rule reflects the House's closer connection to the people through two-year terms. Question 2. What is the constitutional role of the Vice President of the United States within the legislative branch? Option A. Serving as the permanent Speaker of the House of Representatives. Option B. Serving as the President of the Senate, with the power to cast a vote only to break a tie. Option C. Writing the initial drafts of all federal revenue and tax bills. Option D. Directing the scheduling of all legislative floor debates in the Senate. The correct answer is option B. Serving as the President of the Senate, with the power to cast a vote only to break a tie. The Vice President is President of the Senate and normally votes only to break a tie. The Speaker leads the House, and Senate floor scheduling is handled by Senate leadership. The role gives the Vice President a limited legislative function. Question 3. What type of government system allocates power evenly between central and regional authorities so that neither can completely eliminate the other? Option A. Unitary system. Option B. Federal system. Option C. Confederal system. Option D. Autocratic system. The correct answer is option B. Federal system. A federal system divides power between central and regional governments so both have protected authority. A unitary system centralizes power, a confederal system weakens the center, and autocracy centers power in a ruler. Federalism is the middle path between unitary and confederal systems. Question 4. What type of power is the federal government's ability to acquire new geographic territories, which is not explicitly stated but stems from national sovereignty? Option A. Enumerated power. Option B. Reserved power. Option C. Inherent power. Option D. Concurrent power. The correct answer is option C. Inherent power. Acquiring territory is an inherent power tied to national sovereignty, even though it is not expressly listed in the Constitution. Enumerated powers are written, reserved powers belong to states, and concurrent powers are shared. The Louisiana Purchase is the classic example of this idea. Question 5. How does a constitutional republic differ fundamentally from a pure, unchecked direct democracy? Option A. A constitutional republic does not utilize popular voting to select any public officials. Option B. A constitutional republic protects minority rights through a supreme law that limits majority rule. Option C. A constitutional republic combines the positions of chief executive and chief judicial officer. Option D. A constitutional republic gives the legislative branch total immunity from constitutional review. The correct answer is option B. A constitutional republic protects minority rights through a supreme law that limits majority rule. A constitutional republic uses a higher law to limit majority power and protect individual and minority rights. A pure unchecked direct democracy could let a temporary majority override rights without constitutional restraint. Elections still matter, but the Constitution sets boundaries no majority may lawfully cross. Question 6. Which type of federal agency possesses the authority to create regulations that govern specific sectors of the economy, such as the Environmental Protection Agency, EPA? Option A. Government corporation. Option B. Executive Department subagency or independent regulatory agency. Option C. Cabinet Advisory Board. Option D. Legislative Oversight Committee. The correct answer is option B. Executive Department subagency or independent regulatory agency. Regulatory agencies, including executive subagencies and independent regulatory bodies, write rules for specialized policy areas such as environmental protection. Government corporations provide services, while advisory boards and congressional committees do not issue sector-wide regulations in the same way. Agency rulemaking implements statutes passed by Congress. Question 7. What major legislation passed in 1965 created health insurance programs for elderly Americans, Medicare, and low-income individuals, Medicaid? Option A. The Social Security Amendments of 1965. Option B. The Affordable Care Act of 2010. Option C. The Health Insurance Portability Act. Option D. The National Institutes of Health Act. The correct answer is option A. The Social Security Amendments of 1965. The Social Security amendments of 1965 created Medicare for the elderly and Medicaid for low-income individuals. The original 1935 Social Security Act did not create those health insurance programs. Medicare plus Medicaid points to the 1965 amendments. Question 8. The dynamic where state governments act as laboratories of democracy by testing innovative policies describes an advantage of which system? Option A, unitary system. Option B, federalism. Option C, parliamentary system. Option D, direct monarchy. The correct answer is option B, federalism. Federalism lets states experiment with policies, creating laboratories of democracy. A unitary system centralizes policy, while parliamentary government and monarchy concern different institutional structures. State-level experimentation is an advantage of divided state-national power. Question 9. Which executive department is tasked with conducting international relations, managing embassies, and advancing American foreign policy interests? Option A, Department of Homeland Security. Option B, Department of Defense. Option C, Department of State. Option D, Department of Commerce. The correct answer is option C, Department of State. The Department of State conducts diplomacy, manages embassies, and advances foreign policy. Defense handles the military, Homeland Security domestic security, and commerce business and trade programs. Embassies and diplomacy point to state. Question 10. In Federalist No. 10, James Madison argued that the mischiefs of factions could be best controlled by what type of governance structure? Option A, a small, direct democracy with highly localized assemblies. Option B, a large representative republic that prevents any single faction from easily dominating. Option C, a strong, absolute military dictatorship that suppresses political debate. Option D, a confederal system that gives individual states absolute veto power over all national laws. The correct answer is option B, a large representative republic that prevents any single faction from easily dominating. Federalist No. 10 argues that a large republic controls factions by multiplying interests and making domination by one faction harder. A small direct democracy would be more vulnerable to majority passion, and dictatorship would destroy liberty. Madison's answer to faction was representation across an extended republic. Question 11. How does the judicial branch check the power of the executive branch? Option A, by refusing to confirm presidential cabinet appointments. Option B, by declaring executive orders or actions unconstitutional through judicial review. Option C, by voting to impeach the president during times of administrative misconduct. Option D, by adjusting the annual operating budget allocated to the White House. The correct answer is option B, by declaring executive orders or actions unconstitutional through judicial review. Courts check the executive by declaring executive actions or orders unconstitutional in actual cases. The Senate confirms appointments, the House impeaches, and Congress controls budgets. Judicial review is the judiciary's core check. Question 12. Which piece of legislation passed in 1973 protects threatened and endangered plant and animal species and their critical habitats from commercial destruction? Option A, the National Park Service Act. Option B, the Endangered Species Act. Option C, the Fish and Wildlife Coordination Act. Option D, the Wilderness Preservation Act. The correct answer is option B, the Endangered Species Act. The Endangered Species Act protects threatened and endangered species and their critical habitats. NEPA requires environmental review, the Clean Water Act regulates water pollution, and CERCLA cleans hazardous waste sites. Species protection points to the ESA. Question 13. The use of a written constitution to establish clear boundaries for government authority is an application of which political philosophy? Option A, absolute monarchism. Option B, constitutionalism. Option C, totalitarianism. Option D, direct democracy. The correct answer is option B, constitutionalism. Constitutionalism means government authority is created and limited by a constitution. Absolute monarchy and totalitarianism concentrate power, while direct democracy describes popular decision-making rather than legal limits. Written limits are the core of constitutional government. Question 14. What did the Supreme Court rule in the case of Engel v. Vitale, 1962, regarding public education? Option A, public schools must provide equal funding for religious clubs. Option B, state-sponsored, mandatory prayer in public schools violates the Establishment Clause of the First Amendment. Option C, school districts can teach religious texts as historical reference materials. Option D, public funds can be used to purchase textbooks for private religious academies. The correct answer is option B, state-sponsored, mandatory prayer in public schools violates the Establishment Clause of the First Amendment. Engel v. Vitale held that state-sponsored prayer in public schools violates the Establishment Clause. Equal funding for clubs and textbook aid are different religion in schools issues. Government-written or government-sponsored prayer is the angle clue. Question 15. Which branch of government has the ultimate authority to interpret laws and determine their constitutionality through judicial review? Option A, legislative branch. Option B, executive branch. Option C, judicial branch. Option D, electoral branch. The correct answer is option C, judicial branch. The judicial branch interprets laws and uses judicial review to determine whether government action violates the Constitution. Congress writes statutes and the President executes them. Constitutional interpretation in cases belongs to courts. Question 16. Which landmark case placed a clear limit on the scope of presidential executive privilege, ordering the release of audio tapes during a criminal investigation? Option A, United States v. Nixon, 1974. Option B, Clinton v. Jones, 1997. Option C, Bush v. Gore, 2000. Option D, Marbury v. Madison, 1803. The correct answer is option A, United States v. Nixon, 1974. United States v. Nixon limited executive privilege and required the president to comply with a criminal subpoena for Watergate tapes. Clinton v. Jones involved civil litigation, and Bush v. Gore involved election recounts. Executive privilege versus criminal evidence points to Nixon. Question 17. What is the function of a dissenting opinion written by a Supreme Court justice? Option A, to express legal disagreement with the majority decision and outline why the decision is flawed. Option B, to officially veto the majority's decision and send the case back to a lower court. Option C, to summarize the factual evidence presented during the initial trial court proceedings. Option D, to provide a non-binding policy recommendation to the executive branch. The correct answer is option A, to express legal disagreement with the majority decision and outline why the decision is flawed. A dissenting opinion explains why a justice disagrees with the majority's decision or reasoning. It does not veto the majority, retry facts, or send policy advice to the executive. Dissents can influence future legal development even though they do not control the case. Question 18. Which term refers to the power of the people to vote an elected official out of office before their term expires? Option A, impeachment. Option B, recall. Option C, ouster. Option D, censure. The correct answer is option B, recall. Recall allows voters to remove an elected official before the end of the term. Impeachment is a legislative process, censure is a formal reprimand, and ouster is a broader removal term. The key clue is voters acting before the next regular election. Question 19. Which Supreme Court ruling prohibited the use of racial quotas in legislative redistricting, stating that bizarrely shaped districts drawn solely on the basis of race violate the Equal Protection Clause? Option A, Baker v. Akar, 1962. Option B, Shah v. Reno, 1993. Option C, Korematsu v. United States, 1944. Option D, Reynolds v. Sims, 1964. The correct answer is option B, Shah v. Reno, 1993. Shah v. Reno held that race cannot be the sole basis for bizarrely shaped legislative districts without triggering equal protection concerns. It is a racial gerrymandering case, not a school segregation or voting age case. Strange district shapes and race point to Shah. Question 20. How does the United States Constitution limit the power of the federal government to suspend the writ of habeas corpus? Option A, it can never be suspended under any circumstances whatsoever. Option B, it can only be suspended during times of rebellion or invasion when public safety requires it. Option C, it can be suspended at any time by a unilateral executive order from the President. Option D, it can be suspended only if the Supreme Court issues an official judicial advisory opinion. The correct answer is option B, it can only be suspended during times of rebellion or invasion when public safety requires it. The Constitution allows suspension of habeas corpus only during rebellion or invasion when public safety requires it. It is not absolutely unsuspendable, nor may the President suspend it at will. Habeas corpus protects against unlawful detention by requiring legal justification for custody. Question 21. How long is the standard constitutional term of office for an elected member of the United States Senate? Option A, 2 years. Option B, 4 years. Option C, 6 years. Option D, 8 years. The correct answer is option C, 6 years. U.S. Senators serve 6-year terms. Representatives serve 2 years, presidents serve 4, and 8 years is not a Senate term. Longer Senate terms were designed to create stability and independence. Question 22. Which document first advanced the radical idea that governments derive their just powers from the consent of the governed? Option A, the Articles of Confederation. Option B, the Declaration of Independence. Option C, the Treaty of Paris. Option D, The Federalist Papers. The correct answer is option B, the Declaration of Independence. The Declaration of Independence states that governments derive just powers from the consent of the governed. The Articles created the first national government, the Treaty of Paris ended the war, and the Federalist Papers defended the later Constitution. Consent is the Declaration's key political theory. Question 23. Which piece of landmark legislation created the federal framework for safe working conditions, establishing a national enforcement agency for workplace health? Option A, the Fair Labor Standards Act of 1938. Option B, the Occupational Safety and Health Act, OSHA, of 1970. Option C, the National Labor Relations Act of 1935. Option D, the Social Security Act of 1935. The correct answer is option B, the Occupational Safety and Health Act, OSHA, of 1970. OSHA created the federal framework for workplace safety and health standards. Civil rights, environmental, or education laws do not establish the main workplace safety agency. Safe working conditions point to the Occupational Safety and Health Act. Question 24. What did the Supreme Court rule in Abington School District v. Skemp, 1963, regarding Bible readings in public schools? Option A, school districts can require daily Bible readings if students are allowed to opt out. Option B, sanctioned. Corporate Bible reading and Lord's Prayer recitations in public schools violate the Establishment Clause. Option C, Bible studies are permitted only if conducted by certified civilian history instructors. Option D, state funding must be withheld from schools that refuse to display religious symbols. The correct answer is option B, sanctioned. Corporate Bible reading and Lord's Prayer recitations in public schools violate the Establishment Clause. Abington School District v. Skemp struck down school-sponsored Bible readings and Lord's Prayer recitations under the Establishment Clause. Engel involved school prayer, and Abington extended the principle to devotional Bible readings. State-sponsored religious exercises in public school are establishment problems. Question 25. How can the legislative branch check the power of the judicial branch under the U.S. Constitution? Option A, by altering the size of the Supreme Court and confirming or rejecting judicial nominees. Option B, by issuing an executive order that pardons individuals convicted by federal courts. Option C, by removing a judge from the bench through a unilateral decree from the Speaker of the House. Option D, by rewriting a court ruling to reverse a judicial decision directly. The correct answer is option A, by altering the size of the Supreme Court and confirming or rejecting judicial nominees. Congress can check the judiciary by setting the size and structure of lower federal courts, confirming or rejecting nominees, and using impeachment for misconduct. Pardons are executive, and Congress cannot simply rewrite a court ruling as if it were a judgment. Legislative checks operate through appointments, structure, jurisdiction, and removal. Question 26. Which political philosopher's concept of natural rights, specifically life, liberty, and property, heavily influenced the writing of the Declaration of Independence? Option A, Thomas Hobbes. Option B, John Locke. Option C, Jean-Jacques Rousseau. Option D, Baron de Montesquieu. The correct answer is option B, John Locke. John Locke's theory of natural rights taught that people possess life, liberty, and property before government exists. Hobbes emphasized strong sovereign control, Rousseau stressed the general will, and Montesquieu is tied to separation of powers rather than the Declaration's rights language. For FCLE, connect Locke with natural rights and the Declaration's claim that rights are unalienable. Question 27. Which concept describes the idea that the law must be clear, publicized, stable, and just, applying equally to both the government and citizens? Option A, judicial activism. Option B, executive fiat. Option C, the rule of law. Option D, the mandate of heaven. The correct answer is option C, the rule of law. Rule of law means law must be public, clear, stable, and applied to both citizens and government. Judicial activism, executive fiat, and mandate of heaven do not require equal legal accountability. The concept rejects secret, arbitrary, or personal rule. Question 28. In Cantwell v. Connecticut, 1940, the Supreme Court incorporated which First Amendment clause to the states, ruling that a local permit requirement for religious solicitation was unconstitutional? Option A, the Establishment Clause. Option B, the Free Exercise Clause. Option C, the Assembly Clause. Option D, the Petition Clause. The correct answer is option B, the Free Exercise Clause. Cantwell v. Connecticut incorporated the Free Exercise Clause against the states. Everson incorporated establishment, Gitlow dealt with speech, and DeYonga with assembly. Free exercise plus state action points to Cantwell. Question 29. What happens if a presidential candidate fails to secure a majority of 270 electoral votes in the Electoral College? Option A. The election is voided and a new nationwide popular vote is held. Option B. The House of Representatives chooses the president, with each state casting one vote. Option C. The sitting Supreme Court selects the winner by a secret ballot. Option D. The candidate with the most total popular votes automatically wins. The correct answer is option B. The House of Representatives chooses the president, with each state casting one vote. If no presidential candidate receives an electoral college majority, the House chooses the president with each state delegation casting one vote. The winner is not automatically the popular vote leader, and the Supreme Court does not select the president. This is the contingent election process. Question 30. Which system of government concentrates all administrative and governing authority within a single centralized national entity, leaving regional governments with little to no independent power? Option A. Federal system. Option B. Unitary system. Option C. Confederal system. Option D. Anarchist commune. The correct answer is option B. Unitary system. A unitary system places final governing authority in one central national government. Federalism shares power with states, confederation makes the center weak, and anarchism rejects formal governing authority. The key clue is regional governments having little independent power. Question 31. Which Enlightenment philosopher's ideas on social stability and the necessity of a social contract were modified by John Locke to include the right of revolution? Option A. Voltaire. Option B. Thomas Hobbes. Option C. Mary Wollstonecraft. Option D. Cesare Beccaria. The correct answer is option B. Thomas Hobbes. Thomas Hobbes argued that people form government to escape disorder, and Locke later adapted social contract theory to include natural rights and revolution against tyranny. Voltaire, Wollstonecraft, and Beccaria are important Enlightenment figures but not the direct social contract contrast in this question. Hobbes is the starting point for the strong government version of the theory. Question 32. What was the constitutional significance of the Northwest Ordinance of 1787? Option A. It established the initial national banking system for the colonies. Option B. It set a precedent for the orderly admission of new states to the Union and banned slavery in the Northwest Territory. Option C. It authorized the executive branch to buy geographic lands from European powers. Option D. It dissolved the state assemblies of states that refused to pay Continental War debts. The correct answer is option B. It set a precedent for the orderly admission of new states to the Union and banned slavery in the Northwest Territory. The Northwest Ordinance set rules for organizing Western territories, admitting new states, and banning slavery in the Northwest Territory. It did not create a bank, authorize later land purchases, or dissolve state assemblies. It showed how the nation would expand on equal state principles. Question 33. What constitutional limit prevents a state from coining its own independent money or entering into military alliances? Option A. Article I, Section 10 Constraints on States. Option B. The 10th Amendment Reserved Powers. Option C. The Preamble Intent Statements. Option D. The Judiciary Act Mandates. The correct answer is option A. Article I, Section 10 Constraints on States. Article I, Section 10 limits state powers by barring states from coining money, making treaties, or entering alliances. The 10th Amendment reserves powers, but it does not authorize states to act like sovereign nations. State restrictions on money and foreign affairs point to Article I, Section 10. Question 34. Which case addressed the counting of popular votes during a presidential election, halting a state-level recount and effectively determining the outcome? Option A. United States v. Nixon, 1974. Option B. Clinton v. Jones, 1997. Option C. Bush v. Gore, 2000. Option D. Baker v. Carr, 1962. The correct answer is option C. Bush v. Gore, 2000. Bush v. Gore halted the Florida recount in the 2000 presidential election, effectively resolving the electoral outcome. It was not a campaign finance, segregation, or executive privilege case. Vote counting in a presidential election points to Bush v. Gore. Question 35. How often does the Constitution require the federal government to conduct an official population census to reportion the House of Representatives? Option A. Every 4 years. Option B. Every 5 years. Option C. Every 10 years. Option D. Every 20 years. The correct answer is option C. Every 10 years. The Constitution requires a census every 10 years to apportion seats in the House. 4- and 5-year intervals are too short, and 20 years would not update representation often enough. The decennial census is the representation count. Question 36. What is the purpose of a conference committee in the United States Congress? Option A. To To conduct public oversight hearings regarding executive department spending. Option B. To resolve differences between different versions of a bill passed by the House and the Senate. Option C. To choose the majority and minority leadership positions at the start of a session. Option D. To interview potential nominees for vacant federal judge positions. The correct answer is option B. To resolve differences between different versions of a bill passed by the House and the Senate. A conference committee reconciles differences between House and Senate versions of the same bill. Oversight hearings, leadership selection, and nominee interviews are different congressional functions. The goal is one final identical bill for both chambers. Question 37. Which permanent committee in the Senate reviews all potential judicial appointments before they are voted on by the full chamber? Option A. The Foreign Relations Committee. Option B. The Finance Committee. Option C. The Judiciary Committee. Option D. The Armed Services Committee. The correct answer is option C. The Judiciary Committee. The Senate Judiciary Committee reviews federal judicial nominees before the full Senate votes. Foreign Relations handles diplomacy, Finance handles taxes and spending programs, and Armed Services handles military matters. Judicial appointments point to Judiciary. Question 38. Which document served as the first written Constitution of the United States but was eventually replaced due to its creation of a weak central government? Option A. The Declaration of Independence. Option B. The Articles of Confederation. Option C. The Federalist Papers. Option D. The Northwest Ordinance. The correct answer is option B. The Articles of Confederation. The Articles of Confederation were the first written national constitution of the United States and created a weak central government. The Declaration announced independence, the Federalist Papers defended the later Constitution, and the Northwest Ordinance governed Western Territory. Weak national authority is the Article's clue. Question 39. What percentage of individual states must ratify a proposed constitutional amendment for it to become part of the U.S. Constitution? Option A. 50%. Option B. 66%, 2/3. Option C. 75%, 3/4. Option D. 100%, unanimous. The correct answer is option C. 75%, 3/4. 3/4 of the states, or 75%, must ratify a proposed amendment for it to become part of the Constitution. 2/3 is the usual congressional proposal threshold, and unanimity is not required. This high bar protects constitutional stability. Question 40. What landmark piece of legislation established the contemporary framework for federal environmental protections, requiring environmental impact statements for major projects? Option A. The Clean Air Act of 1970. Option B. The National Environmental Policy Act, NEPA, of 1969. Option C. The Endangered Species Act of 1973. Option D. The Comprehensive Environmental Response Act. The correct answer is option B. The National Environmental Policy Act, NEPA, of 1969. NEPA established broad federal environmental review and requires environmental impact statements for major federal actions. The Clean Air Act, Endangered Species Act, and CERCLA address different environmental problems. Environmental impact statements are the NEPA clue. Question 41. Which ancient civilization developed the concept of a Senate as a key component of a representative republic? Option A. Ancient Egypt. Option B. The Roman Republic. Option C. Classic Athens. Option D. The Aztec Empire. The correct answer is option B. The Roman Republic. The Roman Republic developed a Senate as part of a representative republican system. Athens is linked more closely with direct democracy, while Egypt and the Aztec Empire are not the model for the U.S. Senate. Roman institutions influenced the founders' language and structure. Question 42. In Klopfer v. North Carolina, 1967, the Supreme Court incorporated which Sixth Amendment protection to state criminal proceedings? Option A. The right to a public trial. Option B. The right to a speedy trial. Option C. The right to confront witnesses. Option D. The right to compulsory process. The correct answer is option B. The right to a speedy trial. Klopfer v. North Carolina incorporated the Sixth Amendment right to a speedy trial against the states. Gideon concerns counsel, Duncan concerns jury trial, and Miranda concerns interrogation warnings. Speedy trial and state prosecution point to Klopfer. Question 43. Which basic structural power allows Congress to compel individuals to appear and provide testimony during official committee investigations? Option A. The power of eminent domain. Option B. The power of subpoena. Option C. The power of executive fiat. Option D. The power of injunction. The correct answer is option B. The power of subpoena. Subpoena power lets Congress require people to appear or produce information during investigations. Eminent domain takes property, executive fiat is unilateral executive action, and an injunction is a court order. Compelled testimony points to subpoena. Question 44. What type of jurisdiction allows a court to hear a case for the first time, establishing the initial factual record and legal arguments? Option A, appellate jurisdiction. Option B, original jurisdiction. Option C, concurrent jurisdiction. Option D, maritime jurisdiction. The correct answer is option B, original jurisdiction. Original jurisdiction means a court hears a case first and develops the initial record. Appellate jurisdiction reviews decisions already made, and concurrent jurisdiction means more than one court system may hear a case. First hearing equals original jurisdiction. Question 45. What is the fundamental goal of a written constitution in a democratic society? Option A, to guarantee that the economy remains free from any inflation or recession. Option B, to establish the baseline framework, duties, and limits of the government. Option C, to prevent the public from voting on complex tax amendments. Option D, to automate the judicial selection process without human input. The correct answer is option B, to establish the baseline framework, duties, and limits of the government. A democratic constitution establishes the structure, powers, duties, and limits of government. It does not guarantee economic conditions, block all tax votes, or automate judicial selection. Its main job is to set the legal framework for self-government. Question 46. What landmark environmental legislation passed in 1972 regulated the discharge of pollutants into the nation's surface waters and funded sewage treatment plants? Option A, the Safe Drinking Water Act. Option B, the Clean Water Act. Option C, the Toxic Substances Control Act. Option D, the Resource Conservation Act. The correct answer is option B, the Clean Water Act. The Clean Water Act regulates discharges of pollutants into navigable waters and supports sewage treatment improvements. The Clean Air Act addresses air pollution, and CERCLA deals with hazardous waste cleanup. Surface water pollution points to the Clean Water Act. Question 47. In American politics, the concept of a pluralist democracy suggests that power is distributed in what way? Option A, power is held exclusively by a small, highly concentrated economic elite. Option B, power is shared among a wide variety of competing interest groups that influence policy. Option C, power is exercised solely by the sitting members of the United States Supreme Court. Option D, power is completely decentralized to the point that federal laws are entirely non-binding. The correct answer is option B, power is shared among a wide variety of competing interest groups that influence policy. Pluralist democracy views policy as the result of competition among many groups, interests, and associations. Elite theory concentrates power in a few, judicial rule centers power in courts, and total decentralization would make national law ineffective. Pluralism explains how organized groups influence democratic government. Question 48. Which characteristic of ancient Athenian governance is most closely mirrored by modern American democratic practices like state-level referendums? Option A, representative republicanism. Option B, direct democracy. Option C, oligarchical council rule. Option D, hereditary monarchical rule. The correct answer is option B, direct democracy. Direct democracy occurs when citizens vote directly on policy questions, as with many referendums and initiatives. Representative republicanism involves elected officials making decisions, while oligarchy and monarchy place power in a few hands or a hereditary ruler. Ancient Athens is the classic model for direct citizen decision-making. Question 49. Who acts as the official leader of the Senate when the Vice President of the United States is absent from the chamber? Option A, the Speaker of the Senate. Option B, the President pro tempore. Option C, the Secretary of the Senate. Option D, the Majority Leader. The correct answer is option B, the President pro tempore. The President pro tempore presides over the Senate when the Vice President is absent, though day-to-day duties are often delegated. The Majority Leader is politically powerful but is not the constitutional presiding officer. The title literally means for the time being. Question 50. Under the Fifth Amendment, the government's power of eminent domain allows it to take private property for public use only if it provides what? Option A, a written apology from the executive branch. Option B, just compensation, fair market value, to the owner. Option C, a secondary piece of land of equal size in a federal territory. Option D, an exemption from federal income taxes for 10 years. The correct answer is option B, just compensation, fair market value, to the owner. The Takings Clause of the Fifth Amendment requires just compensation when government takes private property for public use. An apology, replacement land, or tax exemption is not the constitutional standard. Eminent domain is lawful only when tied to public use and fair payment. Question 51. Which amendment guarantees the right to a jury trial in federal civil cases where the value in controversy exceeds $20? Option A, Fifth Amendment. Option B, Sixth Amendment. Option C, Seventh Amendment. Option D, Eighth Amendment. The correct answer is option C, Seventh Amendment. The Seventh Amendment preserves the right to a jury trial in federal civil cases above the historical amount in controversy. The Sixth protects criminal juries, while the Fifth and Eighth address other criminal protections. Civil jury trial is the Seventh Amendment Q. Question 52. What was the constitutional significance of the Supreme Court's ruling in Regents of the University of California v. Bakke, 1978? Option A. It banned all forms of affirmative action in higher education admissions. Option B. It ruled that while race can be used as one of several factors in admissions, strict racial quotas are unconstitutional. Option C. It required public universities to provide identical financial aid packages to all applicants. Option D. It declared that out-of-state tuition fees violated the Commerce Clause. The correct answer is option B. It ruled that while race can be used as one of several factors in admissions, strict racial quotas are unconstitutional. Bakke allowed race to be considered as one factor in admissions but rejected rigid racial quotas. It did not ban every form of affirmative action or require identical aid packages. The key distinction is individualized consideration versus fixed quotas. Question 53. Which amendment to the Constitution reserves all powers not explicitly delegated to the federal government to the states or to the people? Option A, First Amendment. Option B, Fifth Amendment. Option C, Ninth Amendment. Option D, 10th Amendment. The correct answer is option D, 10th Amendment. The 10th Amendment reserves powers not delegated to the federal government to the states or the people. The First, Fifth, and Ninth Amendments protect different liberties or enumerated rights. The 10th Amendment is the main textual anchor for reserved powers. Question 54. Baron de Montesquieu's political writings primarily advocated for which feature of democratic governance to prevent tyranny? Option A, popular sovereignty. Option B, direct democracy. Option C, separation of powers. Option D, universal suffrage. The correct answer is option C, separation of powers. Separation of powers divides government authority among branches so no single office can dominate the system. Popular sovereignty concerns the people's source of authority. Direct democracy concerns citizens voting on laws themselves, and universal suffrage concerns who may vote. Montesquieu is the key Enlightenment name to remember for dividing power to prevent tyranny. Question 55. What dynamic occurs during a congressional oversight hearing? Option A, Congress writes amendments to state constitutions. Option B, committees review, monitor, and supervise federal agencies and the execution of public policies. Option C, the Supreme Court presents its annual budget requests to the President. Option D, state governors gather to coordinate regional highway maintenance projects. The correct answer is option B, committees review, monitor, and supervise federal agencies and the execution of public policies. Oversight hearings allow congressional committees to monitor agencies, investigate implementation, and supervise the execution of public policy. They are not state constitutional amendments, judicial budget presentations, or governor meetings. Oversight is how Congress checks the executive bureaucracy. Question 56. Which power is considered a concurrent power shared by both the federal government and state governments? Option A, declaring war against foreign governments. Option B, coining national paper money. Option C, establishing courts and enforcing laws. Option D, creating rules for naturalization of immigrants. The correct answer is option C, establishing courts and enforcing laws. Establishing courts and enforcing laws can be done by both federal and state governments, making these concurrent powers. Declaring war, coining money, and naturalization rules are national powers. Concurrent powers show overlap inside federalism. Question 57. Which basic practice of American democracy allows regular citizens to influence the legislation written by their elected representatives? Option A, filing a writ of habeas corpus. Option B, lobbying, petitioning, and contacting elected officials. Option C, refusing to pay local property taxes. Option D, submitting amicus curiae briefs directly to local police departments. The correct answer is option B, lobbying, petitioning, and contacting elected officials. Lobbying, petitioning, and contacting representatives let citizens shape legislation without holding office. Habeas corpus challenges detention, tax refusal is unlawful, and amicus briefs are legal filings rather than ordinary contact with lawmakers. The First Amendment protects petitioning government. Question 58. Which landmark legislation created the social safety net for retired workers, disabled individuals, and unemployment insurance in 1935? Option A, the Social Security Act. Option B, the Medicare Act. Option C, the Affordable Care Act. Option D, the Welfare Reform Act. The correct answer is option A, the Social Security Act. The Social Security Act created a national safety net for retirees, unemployment insurance, and assistance to vulnerable groups. Medicare and Medicaid came later through the 1965 amendments. The 1935 Social Insurance Framework points to Social Security. Question 59. Which landmark piece of civil rights legislation passed in 1968 prohibited discrimination in the sale, rental, and financing of housing based on race, religion, or national origin? Option A, the Civil Rights Act of 1964. Option B, the Fair Housing Act, Civil Rights Act of 1968. Option C, the Equal Credit Opportunity Act. Option D, the Home Mortgage Disclosure Act. The correct answer is option B, the Fair Housing Act, Civil Rights Act of 1968. The Fair Housing Act, part of the Civil Rights Act of 1968, prohibits discrimination in housing sales, rentals, and financing. The 1964 Civil Rights Act focused more on public accommodations and employment, while the Voting Rights Act focused on elections. Housing discrimination points to the Fair Housing Act. Question 60. The requirement that the President must seek the advice and consent of the Senate for treaties and high-level appointments is an example of which principle? Option A, federal supremacy. Option B, judicial review. Option C, checks and balances. Option D, popular sovereignty. The correct answer is option C, checks and balances. Advice and consent lets the Senate check presidential power over treaties and major appointments. Federal supremacy concerns national law over state law, judicial review concerns courts reviewing legality, and popular sovereignty concerns the people's authority. This is a classic checks and balances mechanism between the executive and legislative branches. Question 61. What is the purpose of the system of checks and balances constructed by the dynamic of the United States Constitution? Option A, to ensure that the federal budget remains completely balanced each fiscal year. Option B, to prevent any single branch of government from consolidating absolute power. Option C, to allow the executive branch to govern without interference from state courts. Option D, to maximize the speed at which federal regulations can be created and enforced. The correct answer is option B, to prevent any single branch of government from consolidating absolute power. Checks and balances prevent any one branch from consolidating absolute power. They are not designed mainly to balance budgets, speed regulation, or free the executive from review. The system uses overlapping powers to make branches restrain one another. Question 62. What constitutional mechanism allows Congress to pass a law over a presidential veto? Option A, a simple majority vote in both chambers. Option B, a two-thirds override vote in both the House and the Senate. Option C, an appeal to the Supreme Court for an immediate ruling. Option D, a referendum vote by 3/4 of the state governors. The correct answer is option B, a two-thirds override vote in both the House and the Senate. Congress can override a presidential veto with a two-thirds vote in both the House and Senate. A simple majority is not enough, and courts or governors do not override vetoes. The high threshold preserves the veto while allowing strong legislative consensus to prevail. Question 63. Which document first established the principle that the monarch's power was not absolute and guaranteed basic due process rights to English barons in 1215? Option A, the English Bill of Rights. Option B, the Mayflower Compact. Option C, the Magna Carta. Option D, the Petition of Right. The correct answer is option C, the Magna Carta. The Magna Carta limited the English king in 1215 and helped establish due process as a restraint on arbitrary royal power. The English Bill of Rights came centuries later. The Mayflower Compact was a colonial self-government agreement, and the Petition of Right addressed later conflicts with the monarchy. The key clue is 1215, which points directly to Magna Carta. Question 64. How are positions within the federal judiciary filled under the rules of the United States Constitution? Option A, appointed by the President and confirmed by a majority vote in the Senate. Option B, elected directly by the public in nationwide judicial primary elections. Option C, selected by a Council of State Supreme Court justices based on senior status. Option D, chosen by a lottery system from among practicing constitutional attorneys. The correct answer is option A, appointed by the President and confirmed by a majority vote in the Senate. Federal judges are nominated by the President and confirmed by the Senate. They are not elected nationally, chosen by state judges, or selected by lottery. This appointment process is another example of checks and balances. Question 65. Which case established that public figures must prove actual malice, that a statement was made with knowledge that it was false or with reckless disregard for the truth to win a libel suit? Option A, Hazelwood v. Kohlmeyer, 1988. Option B, New York Times Company v. Sullivan, 1964. Option C, Texas v. Johnson, 1989. Option D, Schenck v. United States, 1919. The correct answer is option B, New York Times Company v. Sullivan, 1964. New York Times Company v. Sullivan created the actual malice standard for public officials and later public figures in defamation suits. It protects robust debate about public affairs by making libel claims harder for powerful plaintiffs. Actual malice means knowledge of falsity or reckless disregard for truth. Question 66. Which landmark piece of civil rights legislation passed in 1990 explicitly banned discrimination against individuals with disabilities in employment, transportation, and public communications? Option A, the Rehabilitation Act. Option B, the Americans with Disabilities Act. Option C, the Individuals with Disabilities Education Act. Option D, the Equal Opportunity Act. The correct answer is option B, the Americans with Disabilities Act. The Americans with Disabilities Act broadly prohibits discrimination against individuals with disabilities and requires accessibility in employment, public services, and public accommodations. The Civil Rights Act of 1964 covers other protected classes, and Title IX focuses on education sex discrimination. Disability discrimination points to the ADA. Question 67. The Americans with Disabilities Act, ADA, of 1990 requires public accommodations and employers to provide what for individuals with disabilities? Option A, direct financial stipends from the state treasury. Option B, reasonable accommodations and accessible public facilities. Option C, free public transportation passes for life. Option D, guaranteed employment positions within local government offices. The correct answer is option B, reasonable accommodations and accessible public facilities. The ADA requires reasonable accommodations and accessible facilities for qualified individuals with disabilities. It does not guarantee lifetime transit passes, stipends, or automatic public jobs. The key legal standard is accessibility and reasonable accommodation. Question 68. Which system of government combines the legislative and executive functions, choosing the Prime Minister directly from the ranks of the majority party in the legislature? Option A, presidential system. Option B, parliamentary system. Option C, absolute monarchy. Option D, oligarchy. The correct answer is option B, parliamentary system. A parliamentary system combines executive and legislative leadership because the Prime Minister comes from the legislative majority. A presidential system separates those branches, while monarchy and oligarchy describe rule by a monarch or small elite. The key clue is the executive being chosen from the legislature. Question 69. Which system of economy is most closely aligned with the American democratic emphasis on individual liberty and limited government intervention? Option A, command economy. Option B, traditional barter economy. Option C, market economy, capitalism. Option D, state-directed mercantilism. The correct answer is option C, market economy, capitalism. A market economy uses private choice, competition, and limited government direction, matching the American emphasis on economic liberty. A command economy places production under state control, and traditional barter lacks modern market institutions. Capitalism is the economic system most associated with private property and voluntary exchange. Question 70. Which document served as the immediate model for the structure of individual liberty protections found in the American Bill of Rights? Option A, the French Declaration of the Rights of Man. Option B, the English Bill of Rights of 1689. Option C, the German Weimar Constitution. Option D, the Articles of Confederation. The correct answer is option B, the English Bill of Rights of 1689. The English Bill of Rights of 1689 influenced later American protections for individual liberty and limits on government. The French Declaration came after the American founding, and the Weimar Constitution is much later. The Articles of Confederation created a government structure, not the model for the Bill of Rights. Question 71. What constitutional protection prevents the government from passing a bill of attainder? Option A, the prohibition against punishing individuals without a formal judicial trial. Option B, the clause guaranteeing a republican form of government to every state. Option C, the requirement that all revenue bills originate within the House of Representatives. Option D, the protection of patent and copyright records for inventors. The correct answer is option A, the prohibition against punishing individuals without a formal judicial trial. A bill of attainder punishes a named person or group without a judicial trial. It is different from Republican government guarantees, revenue bill rules, or intellectual property protections. The Constitution forbids legislatures from acting like courts in criminal punishment. Question 72. Which amendment lowered the mandatory minimum voting age across the United States from 21 to 18 years old? Option A, 22nd Amendment. Option B, 24th Amendment. Option C, 25th Amendment. Option D, 26th Amendment. The correct answer is option D, 26th Amendment. The 26th Amendment lowered the voting age to 18. The 22nd limits presidential terms, the 24th bans poll taxes in federal elections, and the 25th addresses presidential disability. Voting at 18 is the 26th Amendment. Question 73. What is the minimum age required by the Constitution to serve as a member of the United States House of Representatives? Option A, 21 years old. Option B, 25 years old. Option C, 30 years old. Option D, 35 years old. The correct answer is option B, 25 years old. A representative in the House must be at least 25 years old. Senators must be 30, and presidents must be 35. Age requirements are a common FCLE detail question. Question 74. What historical event in Western Massachusetts highlighted the military and economic weaknesses of the Articles of Confederation, prompting leaders to call for a constitutional convention? Option A, Bacon's Rebellion. Option B, Shays' Rebellion. Option C, the Whiskey Rebellion. Option D, the Stono Rebellion. The correct answer is option B, Shays' Rebellion. Shays' Rebellion exposed the national government's inability to respond effectively to domestic unrest and economic crisis under the Articles. Bacon's Rebellion and the Stono Rebellion were colonial-era events, while the Whiskey Rebellion occurred under the new Constitution. Massachusetts farmer unrest points to Shays. Question 75. Article 3 of the United States Constitution establishes which specific judicial entity? Option A, the Federal Courts of Appeals. Option B, the United States Supreme Court. Option C, the United States Court of Federal Claims. Option D, the District Bankruptcy Courts. The correct answer is option B, the United States Supreme Court. Article 3 establishes the Supreme Court and permits Congress to create lower federal courts. Courts of appeals, bankruptcy courts, and specialized claims courts exist by statute rather than direct constitutional creation. The Supreme Court is the only federal court named in Article 3. Question 76. What did the Supreme Court decide in Schenck v. United States, 1919, regarding speech that obstructed the military draft during wartime? Option A. Such speech is absolutely protected by the First Amendment during all conflicts. Option B. Speech can be limited if it creates a clear and present danger of bringing about substantive evils that Congress has a right to prevent. Option C. The military has the authority to court-martial civilians who print anti-war flyers. Option D. State courts must handle all speech violations without federal intervention. The correct answer is option B. Speech can be limited if it creates a clear and present danger of bringing about substantive evils that Congress has a right to prevent. Schenck held that speech may be limited when it creates a clear and present danger of serious harms Congress may prevent, especially during wartime. The case did not protect all anti-draft speech absolutely. Draft obstruction and wartime danger point to Schenck. Question 77. What was the legal outcome of the infamous Dred Scott v. Sandford, 1857, Supreme Court decision? Option A. It declared that African Americans, whether enslaved or free, were not citizens and that Congress could not ban slavery in U.S. territories. Option B. It established the separate but equal doctrine for public transportation systems. Option C. It ruled that state-level segregation laws were a direct violation of the Privileges Clause. Option D. It forced northern states to pay financial restitution for runaway slaves. The correct answer is option A. It declared that African Americans, whether enslaved or free, were not citizens and that Congress could not ban slavery in U.S. territories. Dred Scott v. Sandford held that African Americans were not citizens and that Congress lacked power to ban slavery in the territories. Plessy created separate but equal, and later civil rights cases rejected segregation. The decision is infamous because it protected slavery and denied citizenship. Question 78. Which clause prevents a state from discriminating against citizens of other states by denying them basic legal rights and access to courts? Option A. The Privileges and Immunities Clause. Option B. The Free Exercise Clause. Option C. The Advice and Consent Clause. Option D. The Executive Prerogative Clause. The correct answer is option A. The Privileges and Immunities Clause. The Privileges and Immunities Clause prevents states from denying basic civil rights to citizens of other states. Free exercise concerns religion, advice and consent concerns Senate approval, and executive prerogative is not the interstate rights rule. The clause supports national unity among state citizens. Question 79. Under the U.S. Constitution, what body has the explicit power to try all cases of impeachment involving federal officials? Option A, the U.S. House of Representatives. Option B, the U.S. Senate. Option C, the U.S. Supreme Court. Option D, the Department of Justice. The correct answer is option B, the U.S. Senate. The Senate tries impeachments and decides whether to convict and remove federal officials. The House brings impeachment charges, while courts and the Justice Department do not conduct impeachment trials. Impeachment is split between the two chambers. Question 80. What major pieces of civil rights legislation passed in 1964 outlawed discrimination based on race, color, religion, sex, or national origin in public accommodations and employment? Option A, the Voting Rights Act of 1965. Option B, the Civil Rights Act of 1964. Option C, the Fair Housing Act of 1968. Option D, the Equal Pay Act of 1963. The correct answer is option B, the Civil Rights Act of 1964. The Civil Rights Act of 1964 outlawed discrimination in public accommodations and employment based on race, color, religion, sex, or national origin. The Voting Rights Act focused on voting barriers, and the Fair Housing Act focused on housing. Public accommodations and employment are the 1964 Act clues. Question 81. Which constitutional officer is second in the line of presidential succession, immediately following the Vice President of the United States? Option A, the Secretary of State. Option B, the President pro tempore of the Senate. Option C, the Speaker of the House of Representatives. Option D, the Chief Justice of the United States. The correct answer is option C, the Speaker of the House of Representatives. The Speaker of the House is second in line after the Vice President for presidential succession. The President pro tempore and cabinet officers follow later in the statutory line. Succession questions often test this order. Question 82. What is the defining characteristic of an authoritarian system of government? Option A, complete adherence to a rigid system of checks and balances. Option B, centralized power held by a political leader or elite group, with limited political freedoms. Option C, direct management of all public utilities by neighborhood committees. Option D, regular amendments to the Constitution via popular referendums. The correct answer is option B, centralized power held by a political leader or elite group, with limited political freedoms. Authoritarian government concentrates power in a leader or elite and restricts political freedoms. Checks and balances, neighborhood control, and frequent referendums describe more limited or participatory arrangements. The key clue is centralized power with limited liberty. Question 83. Which constitutional provision allows federal courts to resolve legal disputes that involve different states or citizens of different states? Option A, diversity of citizenship jurisdiction. Option B, the Full Faith Clause. Option C, the Privileges and Immunities Clause. Option D, original localized jurisdiction. The correct answer is option A, diversity of citizenship jurisdiction. Diversity jurisdiction allows federal courts to hear certain cases involving citizens of different states or disputes between states. Full faith and credit and privileges and immunities govern interstate recognition and rights, not the court's power to hear the case. Diverse citizenship is the jurisdiction queue. Question 84. Which landmark Supreme Court case established the principle of judicial review, granting the federal courts the power to declare acts of Congress unconstitutional? Option A, McCulloch v. Maryland, 1819. Option B, Gibbons v. Ogden, 1824. Option C, Marbury v. Madison, 1803. Option D, Dred Scott v. Sandford, 1857. The correct answer is option C, Marbury v. Madison, 1803. Marbury v. Madison established judicial review, allowing federal courts to declare laws unconstitutional. McCulloch addressed implied powers, Gibbons addressed interstate commerce, and Dred Scott concerned citizenship and slavery. Judicial review is the Marbury memory cue. Question 85. Which type of opinion is written by Supreme Court justices who agree with the majority's ultimate decision but wish to emphasize a different legal rationale? Option A, majority opinion. Option B, dissenting opinion. Option C, concurring opinion. Option D, per curiam opinion. The correct answer is option C, concurring opinion. A concurring opinion agrees with the court's judgment but uses different or additional reasoning. A dissent disagrees with the outcome, while a majority opinion controls the ruling. Concurrence means same result, different rationale. Question 86. Which document was written to justify the separation of the American colonies from Great Britain by listing specific grievances against King George III? Option A, the Federalist No. 10. Option B, the Articles of Confederation. Option C, the Declaration of Independence. Option D, the Bill of Rights. The correct answer is option C, the Declaration of Independence. The Declaration of Independence justified separation from Britain by listing grievances against King George III. The Articles organized the first U.S. government. Federalist No. 10 defended the Constitution, and the Bill of Rights lists liberties. Grievances against the king are the giveaway. Question 87. What major geographic tract of land did Thomas Jefferson purchase using an executive action that tested his strict interpretation of the Constitution? Option A, the Gadsden Purchase. Option B, the Louisiana Purchase. Option C, the Alaska Purchase. Option D, the Florida Cession. The correct answer is option B, the Louisiana Purchase. The Louisiana Purchase expanded U.S. territory and tested Jefferson's strict reading of constitutional power. The Gadsden, Alaska, and Florida acquisitions occurred in different administrations and contexts. Jefferson's major executive land acquisition was Louisiana. Question 88. The 19th Amendment, ratified in 1920, expanded the electorate by granting the right to vote to which group? Option A, naturalized citizens. Option B, Native Americans. Option C, women. Option D, residents of Washington, D.C. The correct answer is option C, women. The 19th Amendment prohibited denying the vote on the basis of sex, expanding suffrage to women nationwide. It did not specifically address naturalized citizens, Native Americans, or D.C. presidential electors. The date 1920 is the major memory cue. Question 89. What piece of legislation passed in 2010 expanded health insurance coverage across the nation through individual mandates and health insurance marketplaces? Option A, the Medicare Modernization Act. Option B, the Patient Protection and Affordable Care Act, Obamacare. Option C, the Health Care Financing Act. Option D, the Children's Health Insurance Act. The correct answer is option B, the Patient Protection and Affordable Care Act, Obamacare. The Affordable Care Act expanded health insurance coverage through exchanges, subsidies, Medicaid expansion mechanisms, and insurance reforms. It is not Medicare's original creation or the 1935 Social Security system. Modern health coverage expansion points to the ACA. Question 90. Which amendment expanded suffrage by explicitly prohibiting the denial of the right to vote based on race, color, or previous condition of servitude? Option A, 13th Amendment. Option B, 14th Amendment. Option C, 15th Amendment. Option D, 19th Amendment. The correct answer is option C, 15th Amendment. The 15th Amendment prohibits denying the vote because of race, color, or previous condition of servitude. The 13th abolished slavery, the 14th guarantees citizenship and equal protection, and the 19th protects voting regardless of sex. Race-based voting discrimination points to the 15th. Question 91. What type of congressional committee is created for a specific, temporary purpose, such as investigating a unique national crisis or scandal? Option A, Standing Committee. Option B, Joint Committee. Option C, Select, or Special, Committee. Option D, Conference Committee. The correct answer is option C, Select, or Special, Committee. A select or special committee is created for a temporary, specific purpose such as investigating a crisis or scandal. Standing committees are permanent, joint committees include both chambers, and conference committees reconcile bills. Temporary investigation is the select committee clue. Question 92. Which clause in Article I gives Congress the authority to regulate commercial business activities that cross over state lines? Option A, the Taxing and Spending Clause. Option B, the Commerce Clause. Option C, the Origination Clause. Option D, the General Welfare Clause. The correct answer is option B, the Commerce Clause. The Commerce Clause gives Congress power to regulate commerce among the states. Taxing and spending concerns revenue and expenditures, while origination and general welfare are different congressional concepts. Interstate business activity is the Commerce Clause signal. Question 93. Which amendment protects citizens from unreasonable searches and seizures by government officials? Option A, Second Amendment. Option B, Fourth Amendment. Option C, Fifth Amendment. Option D, Sixth Amendment. The correct answer is option B, Fourth Amendment. The Fourth Amendment protects against unreasonable searches and seizures. The second concerns arms, the fifth concerns due process and self-incrimination, and the sixth concerns criminal trial rights. Search warrants and probable cause are Fourth Amendment clues. Question 94. Which amendment contains the citizenship clause that grants birthright citizenship to anyone born or naturalized in the United States? Option A, 12th Amendment. Option B, 13th Amendment. Option C, 14th Amendment. Option D, 15th Amendment. The correct answer is option C, 14th Amendment. The 14th Amendment contains the Citizenship Clause, granting citizenship to people born or naturalized in the United States and subject to its jurisdiction. The 13th abolished slavery, and the 15th protected voting regardless of race. Birthright citizenship points to the 14th. Question 95. Title IX of the Education Amendments Act of 1972 explicitly prohibits discrimination based on what characteristic in federally funded education programs? Option A, age. Option B, socioeconomic status. Option C, sex. Option D, religious affiliation. The correct answer is option C, sex. Title IX prohibits sex discrimination in federally funded education programs and activities. It is not primarily about age, income, or religion. Education access and sex discrimination point to Title IX. Question 96. The Necessary and Proper Clause, or Elastic Clause, provides Congress with the constitutional basis for which type of power? Option A, enumerated powers. Option B, implied powers. Option C, reserved powers. Option D, concurrent powers. The correct answer is option B, implied powers. The Necessary and Proper Clause supports implied powers, allowing Congress to carry out its enumerated powers through reasonable means. Enumerated powers are listed directly, reserved powers belong to states, and concurrent powers are shared. The Elastic Clause expands practical congressional authority without creating unlimited power. Question 97. The mechanism of a presidential veto over legislation passed by Congress is an example of what constitutional dynamic? Option A, a state check on federal legislative powers. Option B, an executive check on the legislative branch. Option C, a judicial check on the executive branch. Option D, a legislative check on the judicial branch. The correct answer is option B, an executive check on the legislative branch. A presidential veto is an executive check on Congress because it lets the president reject legislation passed by the legislative branch. It is not a state check or a judicial check. Congress can still respond through the constitutional override process. Question 98. Which principle prevents the federal government from establishing an official national religion that all citizens must follow? Option A, the Free Exercise Clause. Option B, the Establishment Clause. Option C, the Supremacy Clause. Option D, the Full Faith and Credit Clause. The correct answer is option B, the Establishment Clause. The Establishment Clause bars government from creating or endorsing an official national religion. The Free Exercise Clause protects religious practice, while the Supremacy and Full Faith and Credit Clauses address federal law and state records. Establishment is the key term for government-sponsored religion. Question 99. In Murdoch v. Pennsylvania, 1943, the Supreme Court struck down a municipal ordinance requiring a license tax for distributing religious materials, protecting what right? Option A, the commercial liberty of publishing corporations. Option B, the free exercise of religion combined with freedom of the press. Option C, the tax exemption status of state utility providers. Option D, the right of municipalities to regulate public sidewalks. The correct answer is option B, the free exercise of religion combined with freedom of the press. Murdoch v. Pennsylvania protected religious distribution of literature from a license tax, combining free exercise concerns with freedom of the press. It was not a case about establishment, equal protection, or search and seizure. Religious pamphleteering and licensing fees point to Murdoch. Question 100. What does a writ of certiorari issued by the United States Supreme Court signify? Option A, a direct order releasing a prisoner from an illegal confinement. Option B, an official announcement that the court will review a case from a lower court. Option C, a declaration that a federal law has been completely overturned without oral arguments. Option D, a formal reprimand of an executive branch official by the Chief Justice. The correct answer is option B, an official announcement that the court will review a case from a lower court. A writ of certiorari means the Supreme Court has agreed to review a lower court case. Habeas corpus challenges detention, and certiorari is not itself a merits decision overturning a law. Certiorari is about granting review, not deciding the case.